Hello, welcome. We'll give it just a moment here to get folks in from the waiting room. Thanks for logging on to join us for this introduction to the Copyright Claims Board presented by our friends at the U.S. Copyright Office. Wonderful, I see the room filling up. We'll just give it just a moment. I'm Meredith Badler. I'm the Deputy Director at the CBCA, which is the Colorado Business Committee for the Arts. And one of our many programs at the CBCA is Colorado Attorneys for the Arts, or CAFTA, as it is called. And so CAFTA is delighted to host this webinar today in partnership with some of our friends at the Colorado Bar Association from the IP section and the entertainment and sports section. I will give them a chance to say hello in a moment. But a few Zoom housekeeping items for those joining us live on Zoom. Hello to you. This is a Zoom webinar, so you are muted, your camera is off, but we do still want to hear from you. So feel free to use the chat feature. I encourage you to put all of your questions though into the Q&A. You'll see a little Q&A box with two little speech bubbles. That's a great place to put your questions so our wonderful speakers can see them and answer them as they fit into the presentation. There is also closed captioning available if that is helpful for you. We are not live streaming on Facebook. That's that live streaming is our closed captioning. But we are recording today's webinar. So if you are watching this later, hello to you in your day. We are thrilled that we're able to record this great content and make that available afterwards. And for those that don't know, Colorado Attorneys for the Arts, or CAFTA, is our pro bono legal referral service here in Colorado, one of many volunteer lawyers for the arts organizations across the country. And we work with attorneys like you to help connect them to artists in need of legal help. This is a great avenue for particularly transactional attorneys to do pro bono work by supporting our arts sector, and we help facilitate that at CAFTA. We do have a couple partners for this event. I want to give them a chance to say hello before we turn it over to our speakers. Let's see if they're on. I know joining us from the entertainment and sports section, we have Dave Ratner. Dave, do you want to say a quick hello?
Yeah, thanks, Meredith. I'm Dave Ratner. I'm the chair of the entertainment and sports section. We're proud to co-sponsor this with CAFTA. Our section does a lot of other CLEs on all sorts of interesting topics, not only to entertainment and sports practitioners, but to folks throughout the IP and business law communities. So we encourage you to check out our section and the other CLEs that we do. Also, I will also give a plug for CAFTA. If you are an attorney interested in working in the arts, please check out CAFTA. We love to have more volunteers. You get some really cool opportunities through CAFTA as well.
Thanks, Dave.
Thanks.
Joining us, awesome. And joining us from the IP section, who's been just so helpful promoting this event as well. We have Deb Howitt joining us. Deb, do you want to say a quick hello?
Yes, thank you so much. Yes, we're also happy to co-sponsor this. I think it'll be a great presentation. I wanted to let everybody know that the IP section, together with the communications section, will be hosting a happy hour on November 29th at 5:30 at Avanti. So we encourage you to come and check out the IP section. We'd love to meet you all. We're also looking for additional people to become involved in the section in a leadership role if you're interested, or if you're interested in becoming a speaker. Please feel free to message me, I guess, in the chat here, or my email is howitt.deb@dorsey.com. That's HOWITT. And thank you so much.
Thanks, Deb. That sounds like a great happy hour. Avanti's a fun spot.
Yes.
All right. Well, I'm going to kick it over for our content today. This is a 1-credit CLE. I'll make sure you have that information at the end. And we are joined by Monica, Whitney, and Laura from the U.S. Copyright Office to talk to us about the still brand new Copyright Claims Board, how you all as attorneys navigate that, how to advise clients, how it works. Take it away.
Hello, everyone. Thanks for joining. I'm Monica McCabe, one of the copyright claims officers before the Copyright Claims Board. And I'm going to go over a little bit of background and the kinds of claims we can handle and damages and things like that. Laura is going to navigate you through our online docket managing and filing system, ECCB, and show you how some screenshots how to do that. And then finally, Whitney is going to go over our stats thus far. We opened on June 16th to tell you about how many claims we have, what kinds of claims, and also some of the mistakes that claimants are making when they file, which causes us to have to reject their claim and have them redo it. So with that, I'll start in. Next slide, please. So I just want to introduce you to our team. As I said, I'm one of the copyright claims officers. I joined from the Phillips Neiser, which is a law firm in New York City, as head of the intellectual property department. David Carson is another officer. He was the former general counsel of the Copyright Office for many years, and then was at the USPTO for quite a while. Brad Newberg is the third copyright claims officer, and he joins us from a firm in the DC area where he was also head of copyrights and trademarks. Whitney joins us from many years at the Copyright Office, and you'll be hearing from her later. Dan came from private practice. Maya was in the Copyright Office for a number of years in the registration division. And Laura is our paralegal, graduated from George Washington Law School last year and has passed the bar. Yay. And finally, our specialist and assistant, Natalie Cronin, joins us from Georgetown's School of Foreign Service. So we have a great team that's really excited and motivated to get this going. Next slide. So how did the CCB come to be? The problem was that very few attorneys were willing to handle small claims because it's very expensive to go to federal court, and a lot of times the damages just don't make it worth it. So small owners felt like it was not worth pursuing their claims. Sometimes accused parties felt pressured into settlements that they didn't really think were fair. And in some cases, judges in small courts had little experience with copyright. And as you probably know, if you go before a jury, it's always unpredictable. Next slide. So here's a bit of the timeline. As a result of those issues, some groups like the Songwriters Guild and the Authors Guild started pushing for a small claims tribunal that would hear only copyright disputes. And in 2006, that's when there was a hearing held on small claims and orphan works. Congress asked the Copyright Office to issue a study on the possibility of having such a tribunal. The report was released in 2013. And finally, a bill was introduced in 2016. As you see, it took a number of years before it got passed. It actually got passed with the COVID Relief Act at the end of 2020. And thereafter, the Copyright Office started making preparations and implementation. We had a very short deadline, 18 months within which to get the whole thing launched. And we actually came in a little before deadline on 6/16. So what kinds of claims, counterclaims, and defenses can you bring before the Copyright Claims Office? Obviously, they all have to do with copyright. First and foremost, and where we get a lot of our claims, are copyright infringement claims. We also can hear declarations of non-infringement claims where an infringer asks us to declare whether they are infringing or not. And then finally, a 512 misrepresentation claim where there's a misrepresentation in a takedown or counter notice for online material under the Digital Millennial Copyright Act. We can hear all kinds of legal and equitable defenses that you can use in federal court, including fair use. Next slide. Thank you. So this is just a chart that kind of explains how the initial procedures are handled at the CCB. The claimant files a claim on ECCB, which we'll talk about more later, and it goes to a CCB attorney for compliance review. And we look at are the damages they're asking for proper, are the claims proper. Sometimes we get claims for patent and all kinds of things. Is there a foreign respondent? We can't hear claims in front of foreign entities or individuals. So if the claim is compliant, we send out an order telling them to serve with other directions in it. And then the claimant has 90 days to complete service and file proof of service with us. That's been a daunting task for a lot of claimants, the service part of it. And, if you do get involved, I think that would be really helpful knowledge you can give them in terms of, how to properly serve in the state you're handling a claim in. And then the respondent has a choice. Because we're not Article 3 judges, the CCB is a voluntary tribunal. So therefore, the respondent has the right to opt out and say, I don't want to be involved. And they have 60 days in which to do that. And it's fairly simple for them. They get a code and they plug it in on our ECCB system and they're done. If they decide they want to go forward, then it becomes an active claim and they file a response and perhaps a counterclaim. We do hear counterclaims as well for similar issues. Going down to the next row, if the claim is not compliant, we issue what's called a non-compliance order explaining what's wrong with it. And then the claimant has 30 days to fix it. And then if it comes back, many of them do, it goes through compliance review once again. And if it's still not compliant, they have another 30 days to fix it. If it's compliant at that time, we issue a notice of compliance and tell them to serve it. But there's 3 strikes and you're out. The last time, if they don't fix it properly, we dismiss the claim without prejudice. They can refile the claim before us or in federal court. Next slide, please. So here's a little bit after, if a respondent decides they're going to stay in the case, what happens. So they file a response in any counterclaim they may want to bring. There's limited discovery. We have created standard interrogatories and doc requests that each of the parties will need to respond to. People can ask for additional discovery, but that we'll have to see, on a case-by-case basis, whether that is warranted. Then we'll go to written testimony. Everything, the claimant and respondents will lay out their case, put in witness statements if they want, and other evidence. Then there's a virtual hearing. All of our work is done virtually on Zoom. So we have a virtual hearing room so that no one has to travel to DC. Having a hearing at this point is optional. The parties can request it, or perhaps the officers believe that it would be helpful to have a hearing. And if there's a hearing, then afterwards, or if not, there'll be a determination one way or the other on the claim. We will encourage settlement at any time, and we'll facilitate settlement conferences. I'm actually the ADR officer of the 3 of us, who is supposed to have experience in mediating cases and things like that. So we have seen some cases already settling even before they get to the active phase, which is a good sign. And we also have instituted safeguards against defaults so that we send out a second notice when a if a respondent hasn't opted out yet, after a certain period of time, we send out a second notice to remind them that they need to respond one way or the other. Next slide, please. So as I said, we have standard interrogatories and document requests, which will be found on our website, ccb.gov. And as I said, you can request more discovery, it will always be granted. There's absolutely no depositions permitted. We don't have the power to issue third-party subpoenas. So if there are documents and things that the claimant needs from outside, they may want to go to federal court because we don't have the power to force people into producing documents or asking questions. Expert testimony is not favored and will rarely be granted. There may be some special cases where it may make sense to have an expert witness, but of course, that'll drive up the cost of the proceeding, which the whole part of the whole thing was to keep costs down and to streamline things so that it can be done fairly quickly and inexpensively. Next slide, please. Monetary awards that we grant cannot exceed $30,000. In smaller claims proceedings, which I'll talk a little bit more about in a minute, the claim is reduced to $5,000. So for claims of infringement, the claimant can get actual damages and the infringer's profits if attributable to the infringement, or statutory damages. Statutory damages depends on the registration status. If it was properly and timely registered, they can get up to $15,000 per work. If not, they can only get up to $7,500 per work. And unlike in federal court, you don't have to actually have the registration in hand when you file, but you have to have at least filed an application for registration at the time you file a claim for infringement. Next slide, please. So I mentioned the smaller claims, and as I said, these cases are only up to $5,000. This discovery will be even more streamlined. The officer will go over with the parties, what discovery is really needed, and focus just on that, as opposed to having them do all of the standard interrogatories and doc requests. There'll be, several conferences between the parties and the copyright claims officers to guide them through the process. And in, almost all cases, standard track cases, there'll be 3 officers making the decision. In the smaller claims, it's only 1 officer that will make the final determination unless there's a default by the respondent. Next slide, please. So what are the benefits of going before the CCB? And if you have a potential client, they may ask you, well, why should I do this? If they're a respondent, the good thing is that damages are limited. It's in general, it's just a lower cost because of the streamlined procedures. Depositions, as you probably know, cost a fortune. They don't have to have a lawyer. They can represent themselves. Unlike federal court, corporations and associations can be represented by an employee, an officer, a director. In federal court, they're required to be represented by lawyers. So there'll be lower risks of default, as I said, because of the reminders and things that we send out. Because there's only 3 of us and we have a small team, we'll know who the bad actors are very quickly. And we will closely monitor those. And we do have, sanctions and things like that to deal with those kinds of situations. The findings will be more consistent because there's not hundreds of judges, there's only 3 of us. And all of us, the officers, have represented both content creators and users. So we, aren't biased one way or the other, we're impartial, and we all have substantial copyright experience. I think among the 3 of us, we have over 90 years of copyright experience. Next slide, please. I think, is this, Laura, this is where you take over. So I'm going to hand it over to Laura to give you some more about technology and ECCB. Thanks for listening.
Thanks, Monica. So as Monica mentioned, I'm going to be going over ECCB and kind of what that looks like, and then also some areas where we think you all can help. So ECCB is our case management system. So this is where you'll register to file cases, to respond to cases, opt out on behalf of clients. You can register and then you can also receive notifications through ECCB. Once you link your email, you'll get notifications when there's a filing. And anyone can view any unrestricted documents through the public case search feature. So you don't even actually have to register to see our public claims, orders of dismissal, notices of compliance, orders to amend a non-compliant claim. All of that you can see without even registering on the website. We also have a designated service agent database. You can access that through ccb.gov. This is where corporations, partnerships, unincorporated associations can file a submission designating a service agent. And that way, you know, when claimants file, they're supposed to look in our database and see if there is a service agent designated for service. So this is what ECCB looks like. Once you've registered and have an account, you'll see a dashboard with various buttons to do all of the functions that you need to for claims. You can start a claim from scratch, claims that you've started and saved in the system. You can click that button, complete started claims, to restart a claim that you already have. Obviously responding to claims or counterclaims. There's a separate button to amend a claim. And then for file an existing case, that will be to file different documents that we have available. So, you know, requests for third party to attend a hearing, or maybe you're filing your appearance as an attorney in a case. That button will allow you to select whatever document type that you'd like to submit to us. And there'll be different instructions about whether you're filling in a text field or uploading a separate file. You can see down here, we have ongoing copyright proceedings. This is for cases that you filed. Once they're in the system, they should populate here. So it'll help you keep track if you have multiple claims going. So this is the first screen that you'll see when you start a claim, this claim type selection page. As you can see, you also have an option here to continue a filing that you have not completed but have saved in the system. We also have helpful reminders, particularly for our participants who are proceeding without an attorney, like these tooltips, which are these eye icons, which will pop when you hover over them. They have some extra information or links to our various resources, such as the CCB handbook. As you can also see here, you can click one or more of the 3 different types of claims that the CCB hears. This is the second page that you'll see when you start a claim, after you select the type of claim that you're proceeding with. It's the smaller claims selection. There'll be another opportunity later in the claims flow to change this selection, but this is the primary page where we want to give people as much information as they need to make a decision about whether they're going to proceed on the smaller claims track. Because after this is submitted, it's on this track and there's going to be a very limited opportunity to change it. So we want people to be very sure that they understand what it means to be on the smaller claims track as opposed to the regular small claims track, and make that decision here. This is after you do the smaller claims selection, this is what you'll see, and it's the full claims flow. So as you can see, we have steps 1 through 8. The first step is to put in your claimant information. So you'll add a claimant by clicking this blue button with the plus sign here, putting in name, address, contact information. If you're representing the claimant, there'll be various helpful features for you that you'll see that you'll select that you're representing them, and then you'll be able to put in your attorney information. The next step, respondents, it's going to look very similar to this page, and it will just have this, again, this blue button with the plus sign to add a respondent, and it'll be a similar pop-up window to put in all of the respondents' information. Step 3, this is the claim type. We put in this feature just to kind of remind people, okay, you've selected, a claim for infringement, a declaration of non-infringement, or misrepresentation. Are you sure that those are the selections you want to proceed with? And then that's the step that also has the second time that you'll see the smaller claim selection, just so you can just reorient yourself and make sure that you're on the right track. Steps 4 through 6 are our 3 different types of claims. If you've only selected that you're proceeding with a claim for infringement, you'll only see that step 4. You won't see non-infringement risk misrepresentation. Likewise, if you're filing a declaration of non-infringement, you will only see that step populate. And then once you've completed all of the information in those sections, there's various questions, text fields. There are tooltips to help people if they're not sure what to put into our open text boxes. But we've tried to make it as user-friendly as possible, because again, part of the purpose of the CCB is that people should be able to use the system and fill it out without representation. So it should look fairly straightforward. Step 7, documentation. This is where people can upload various documents. We accept all different types of documents, PDFs, Word documents, video and audio files, anything that the participant would like to be considered along with the claim. And then the final step is step 8, review and pay, and I'll show you what that looks like. So this is the pay.gov page. All of our payments are handled through pay.gov, so that's why it looks a little bit different than ECCB. Very straightforward. You'll select how you want to pay and put in the information. The first payment is $40. We've split the payment into 2 stages. So the first payment is $40 to file the claim. The second payment of $60 is not due until after the claim goes through compliance review, is properly served, and enters the active phase. And there'll be a notification and order actually uploaded to the docket that orders the claimant to pay that second fee of $60. So you'll know when that's coming. I wanted to also show you all a little bit about responding to a claim. The flow looks very similar to the claim flow, but you'll just click respond to a claim here. And then you can select the claim from the drop down and obviously indicate whether yes or no, whether you'll be filing any counterclaims. This is important because the counterclaim step will only populate if you select yes. So that's what that looks like. And then to opt out, you actually don't need to have an account to opt out of a proceeding, but you will need the opt-out key code. And that is available on the initial notice that will be served on the respondent. And it will be on the second notice that the Copyright Claims Board sends out as well. It is unique to each respondent. So if there's multiple respondents, they each have their own unique key code that has to be entered. You'll obviously enter all of the required fields, have the red asterisk, and then you certify whether you're the legal counsel or authorized representative here. And then sign and submit. It's really straightforward. We do recommend doing it electronically through ECCB and not filing a paper form because you receive automatic confirmation that it has gone through. So these are some areas where we think attorneys can be helpful with Copyright Claims Board matters. As we've mentioned, the system is designed to be used by participants proceeding, without an attorney, but there is definitely a lot of areas where we think it will be really helpful for our participants to have some assistance. Areas like registration, if they're confused about what number to put on the form for an application or something that's already been registered, or maybe what document to upload to show us proof of that registration. Obviously, general strategy and what type of claim they should be bringing. Is it infringement claim? Is it misrepresentation, et cetera? Generally filing the claim or response, all of our online system has a lot of helpful tool tips along the way and tries to guide people, but definitely telling their story and putting all of that into a narrative, there's definitely room for help there. the decision whether to file a smaller claim, you know, they might not be completely sure which track they should be on. Obviously, discovering and gathering evidence, that will come a little bit later in the proceedings, but that can obviously also be a complex area. Preparing written testimony and witness statements, that also comes later in the process. But and then also appearing at conferences and hearings, you know, they might want support appearing before the board, before the officers, helping to respond to questions that we have, et cetera. And then also finally preparing a request for reconsideration. So we have lots of resources available to participants and our attorneys. So we have ccb.gov, which has links to many of the features I've already described. There's a link to ECCB. There's a link to our designated service agent database here, our libraries and archives opt-out list. The handbook is especially helpful. It includes plain language instructions for various stages of our proceedings and tries to put our regulations into easily understandable broken down chapters. So that's also good to check out. We also have various, you know, educational graphics and tutorials to kind of guide people through the process. And there's also links to the CASE Act and our regulations under the resources tab on our website as well. So I'll now turn it over to Whitney to go over how it's going, some of our statistics, and some compliance issues that we are seeing.
Hi, good afternoon. Thank you very much for attending our webinar today. Yeah, let's talk about a little bit about how it's going. Laura, let's take us to the first stats slide. So through the end of October, we received 225 claims. Over the past week, we received an additional 7 for eight claims for a total of 233. But this is just a sense of progress over time within our not quite 5 months of operation. You'll see that we received a significant spike on our first day of claims, a lot of enthusiastic filers. And from then on, when we do receive claims, that's just, you know, it's a couple a day where you're seeing larger spikes, where you're seeing maybe half a dozen to a dozen claims. Those are days where we have either a claimant with a number of different claims against different respondents, or we're looking at an attorney who is filing a number of claims on behalf of different clients. Next slide. Of these claims, the vast majority of them have been infringement claims. We have seen a recent increase in misrepresentation claims. We have 24 of those. We do have a few that have brought claims of both misrepresentation and infringement. But you'll see that we've had no independent non-infringement claim. And I think that the 2 claims that we have with non-infringement alleged are still in compliance review. And so yes, so people are bringing their infringement claims. It's a variety of infringement contexts. You know, we are seeing you know, close, well-known relationships between claimant and respondent. We are seeing more arm's length infringement claims. We're seeing infringement claims in the online marketplace, in online distribution context, in physical distribution. So really what we're seeing is a wide variety. Just within a large infringement number, we are seeing you know, many variables about the fact patterns that claimants are bringing to the CCB. Next slide. And this is another example of the variation that we're seeing. This is a representation of the types of works by percentage that are associated with the claims. The largest number that you see on the screen, I see that the key's cut off. So the big chunk is pictorial, graphic, and sculptural works. That's 51%. And you know, big chunk could also describe the category of pictorial, graphic, sculptural works, right? That's a broad category. And as you might imagine, that there are a number of photography claims within that 51%, but we are also seeing, you know, a good representation of works across the category. So, you know, we do have a number of sculptural claims. two-dimensional designs placed on artwork, graphic design, two-dimensional fairy wings. So, within that broad category, there's sort of a more further anecdotal breakdown. And I'll note where we get these numbers for type of work. In the application claims flow that Laura showed you, one of the questions is, to identify the work based off of the section 102 categorization. So section 102 gives us pictorial, graphic, sculptural works. So that's our chunk. The next, that 15% represents motion pictures and audiovisual works. The next, the 12% and the 9%, those are both our musical works chunks. No, I apologize. The 12% is the literary works. So these are things like books. We have some online instructions. We have some online manuals. So a bit of mixture between traditionally distributed literary works and online. And then that next two chunks, the 9% and the 6%, those represent our musical claims. So the 9% is our sound recordings, and our 6% is our musical works. We'll talk a little bit more about non-compliance later, but one pattern that we are seeing from our claimants who bring musical claims is that there is some untangling that needs to be done often between the musical work copyright, the sound recording copyright, and which is at play in the particular claim. The 2% represents sound recordings, and our 4%, that's other. So, we do ask for that one, or not sound recordings, excuse me, software. 4% represents other. We do have a claim where, or a category that people can select when they recognize that they feel like that their work doesn't really fall under a particular category very well. We just received a claim like that last week. So you'll see that we have that 51% of pictorial, graphic, sculptural works, about half of our claim, and then the remaining three remaining categories that are relatively equally balanced across. Next slide. So let's take a look at representation. About 2/3 of claimants that file with the CCB are self-represented. I'll make a note about this third category that we see with where it says represented by in-house attorney or authorized company representative. This is a rule that we have adopted more from state small claim court that allows for flexible representation of business entities. In federal court, in traditional copyright litigation, businesses could only be represented by an attorney or could only appear through an attorney in federal court. Many state small claim court allow authorized business representatives to appear on behalf of the business. And so this could be an owner, a partner, a member, someone with control or fiduciary duty to the business entity, or is authorized by the business, or someone with a fiduciary duty to appear on behalf of the business. So this is a unique way for businesses to participate in CCB claims, but know that we do consider when there's an authorized company representative used, we consider that to be self-represented in the same way that an individual might appear pro se. Next slide. Thanks. So let's take a look at what's happening after compliance. So far, Monica walked us through the structure of the initial proceeding stage. After we have ordered something through to compliance, we have seen eight claims where the claimant has served the respondent and the respondent has opted out. We've had 3 cases move into the active phase, which means that opt-out period ended. And so then it's now time for the claimant to pay the second filing fee, the respondent to register for ECCB. And then we also have a referral for district court, which is worth mentioning to this audience. We do have the ability to accept referrals of active infringement cases in federal district courts. So federal district courts, there's an infringement claim that's initiated in the federal court. At some point in the federal litigation, the parties recognize, or the court recognizes, that the CCB is a useful venue for resolving your dispute. The district court may refer that infringement lawsuit to our district, to our jurisdiction. And we received our first referral just a month or so ago. So this is something to keep in mind if any of you out here engage in regular copyright litigation, that we are another tool in the alternative dispute resolution toolbox. Next slide. So yeah, that first chunk of compliance review, right? So that's the first sort of significant administrative step that we take. Here's kind of a look at sort of the actions that we have taken. So we have issued 75 round one notices of compliance. We've issued 69 orders to amend the non-compliant claim. Then for those that have been ordered to for non-compliance, we have responded to 23 amended claims, finding 14 of those to be compliant and finding 9 of those to be non-compliant again. And then that third chance to file an amended claim, 4 of those we have dismissed. So as Monica mentioned, that there is 30 days after we issue an order of non-compliance to file an amended claim. And you'll see that we have had 18 claimants who have declined to file an amended claim within the time period. Next. So here's a look at all of the states that we have. We have had, I think, over 35 claimants from over 35 states. So we are starting to see an increase in the variety of states. You'll see that we've had a pretty good amount from Colorado. We've had 7 claims. Of course, California and New York have been some of our largest jurisdictions as we've gotten started. But you'll see that we've had claims from all 4 corners of the United States. And we expect through additional outreach that we can hit all 50 maybe someday. But yes, so you do see that that there are the traditional copyright jurisdictions are reflected in some of our numbers. Next. And in terms of our jurisdiction, we can't hear a claim against a foreign respondent, but a copyright owner who is a resident of another country can bring a claim before the CCB. And so you'll see that we've received quite a few claims from foreign countries, many from Europe, from Asia, and from South America. Next. So let's just talk a brief second about the compliance issues we're seeing. So there are sort of some threshold jurisdictional issues that we're seeing, and one of them is registration and a foreign respondent. And Laura went through and detailed all the ways in which legal assistance might be helpful to a participant in the CCB proceeding. And registration help registration is a precondition. You just have to have that application on file before the CCB claim comes in. And then with foreign respondents, legal assistance or research could help identify or find a respondent and determine whether or not the CCB's jurisdiction is appropriate. In terms of issues in infringement claims, we are looking at issues of access and substantial similarity. We are also looking at issues of legal or beneficial ownership. The standing to sue is different in the CCB. And so you have to be the legal or beneficial owner of copyright or the right that's being asserted. So you have to be an exclusive licensee, an author, the owner, the owner of all rights that have been transferred in writing. And we've had some issues with claims that have come through where there's no sort of evidence on the face of the claim of legal or beneficial ownership. The other thing that we are seeing is an issue with OSPs and secondary liability. If we are unable to find a claim compliant unless a claimant confirms that they sent a timely takedown notice and that the OSP failed to expeditiously remove the material. And so, we want to make sure that, claimants that have claims against OSPs understand and are aware that, that it's not just any sort of claim that can be brought before the CCB, but one where, there is a confirmation that the OSP may not be following its 512 obligations. Misrepresentation has been tricky in many ways because, of the scope of misrepresentation. It's about copyright, right? It has to be about, a misrepresentation has to be about copyright. And it has to be in a notice or in a counter notice. We've had a few misrepresentation claims where the false statement is happening outside of the notice or counter notice. And then we have to also have a harm due to the misrepresentation itself, that false statement, rather than the related infringing activity. So there's definitely sort of instructions that we've had to provide related to properly scoping a misrepresentation claim. So that's a quick review of our compliance issues. I believe we might have one more slide okay. So this is about damages. This goes back to the jurisdiction and sort of the power of the CCB to grant certain types of relief. And when it comes to compliance, there are a couple of things to keep in mind. One is that a CCB we have that limited injunction power. We can only grant injunctions when the respondent agrees. We cannot issue monetary awards outside the limits. So, if you ask for damages, traditional statutory damages of $150,000, that's way beyond our jurisdiction. And then also, we don't have that same willfulness penalty as in federal courts. So, we do, if we do see damages issues that are outside of our power to grant, we will write and let the claimant know. Next slide. Okay, there we go. So thank you very much. I think Meredith mentioned I should drop the questions, the Q&As in the chat or in the Q&A box. We are so glad to be here with you today, and we're happy to answer any questions within the context of this webinar or afterwards.
Great. So we do have one question so far in the Q&A, and I'll just read it out. Will you address the effect of a judgment, res judicata, appeals, enforcement, etc.?
I can answer that one. So our judgments do not have precedential value. Someone is not supposed to go to federal court and cite them. There are limited appeals from CCB determinations. So an unhappy party can first do a request for reconsideration to the registrar of copyrights on a limited basis, and it's really an abuse of discretion basis. There's also another larger fee to pay for that. After that, they can go to federal court and make an appeal, but really it's based on bad faith or fraud or a mistake in the judgment. It's very limited in terms of that. Once we make it a determination, that claim can't be brought again between the same parties on the same claims. So that's the res judicata effect. If we issue an award, let's say $5,000 to a claimant, and the respondent doesn't pay, they can go to federal court and have it enforced. I think that answers the question, but if there's any more, let me know.
Okay, I'll go on to the next question because we've got in a couple more in the last minute. Can you clarify what happens if the respondent does not respond in any way?
Whitney, you want to take that one?
Yeah, absolutely. So if the respondent does not respond in any way, we'll first clarify, respondent in any way. So there's a couple things that can happen. So first is the claimant must effectively serve, right, the respondent, and that's what starts the opt-out period. If the respondent does not opt out, the claim goes active. And so I'll just focus my answer here, and say that, we have an active claim and we have a respondent that doesn't participate. We have multiple rounds and safeguards when the respondent is in default, meaning that they're not meeting deadlines, they're not participating, they're not signed up for EC, like they're just not there. And the first thing that we do is we issue that notice of default. We let the respondent, we give them another chance. We want to make sure that we have people that participate. If that doesn't happen, then we ask the claimant for any evidence that they might have, make a statement. So any sort of facts that they would have related to their making their case. The board then takes that into consideration, takes the claim into consideration, and they make a decision about what they're able to, what type of determination they're able to issue. They'll issue this proposed determination and give the respondent the ability to respond to this proposed determination. And so then this is another opportunity for the respondent to come to us and to start to, to engage. The respondent then has the ability to give any sort of information that tells their side of the story. If they do, the officers will take that into account before issuing a determination. And here's the thing, if the respondent, so we have this proposed default determination. If the respondent continues to not respond, the officers will issue that default determination as a default determination. And then the respondent has the opportunity to take that to a federal court, as Monica laid out. They have the opportunity to challenge that and to ask the federal court to set it aside. If the respondent decides, if the respondent does provide information and participates and gives their side of the story at this point, the officers will issue whatever determination they make after taking respondent's side into account as a final determination. And that final determination is then set to that sort of that request for reconsideration, request for registrar's review, like that sort of stepwise thing. So that's a look at our default. It looks very different from what happens in federal courts.
Okay. We have one more open question in the Q&A. If someone makes a claim, a quote troll, can the accused go to the board?
So I'm not sure if I understand the question. Anybody else want to take it before I take a shot?
Yeah, so I think that I would assume from the question that that there's a demand letter or a threat or something like that. And what could someone who receives that demand letter, what could they do? And there I'm thinking, you could file a claim of non-infringement, right? So if you believe you have this potential, threat of an infringement claim on the table, you can definitely you can go to the board, ask for a declaration of non-infringement, provide, all of the reasons why, you believe that it's your use is not an infringement. And so, that's a good point, that this system is here for both copyright owners, but then also is here for copyright users. And we can be a forum for resolving disputes from the non-infringement side.
Okay, great. I don't see any additional questions in the, oh wait, I just came through.
I just see one in the chat that asks for a copy of the slides, and I think Meredith, you could take care of that for people that want copies of the slides.
Oh, yes, that's the next question in the Q&A too, receiving a copy of the slide. Yes, we'll make sure.
And Meredith says, yes, she can share some copies of the slides. So yeah,
Okay, perfect.
anyone that wants them can get them.
Any other questions that we can answer? Nothing else. All right, Meredith, I might turn it over to you at this point if you'd like.
I'm here. Thank you. Thank you, Monica. Thank you, Whitney. Thank you, Laura, for sharing so much great information. I will absolutely share a copy of the slides, as well as some of those additional resource materials that you all provided in advance, some helpful guides, the handbook, directions on how to navigate the website. I did also just put in the chat, and we'll also send out via email the CLE accreditation information for all of you that participated today. You can get 1 CLE credit. And we also recorded today's webinar, and we will make sure that is available. In closing, I would just like to say on behalf of Colorado Attorneys for the Arts and our partners at the IP section and the entertainment and sports section of the bar, it is really important for us to protect our creative content producers, our artists here in Colorado, and having something like the CCB is a wonderful resource. And all of you who have watched this webinar and participated, I just want to thank you for your work to protect the creative work of our Colorado artists and creatives. So please keep up that good work. Colorado Attorneys for the Arts is a great way to do that, but supporting the arts and our creatives through your own legal representation is great as well. So with that, we will wrap up for today. Thank you again, Monica, Whitney, and Laura. Have a wonderful rest of everybody's afternoon. Thank you.
Thank you, Meredith, for
Meredith.
organizing it.
Bye-bye.
Thanks, everyone.